Good afternoon, everyone. Allison Schaberg here with Consolidated Planning Group, and we are partnered today with the Weeks Law Firm, Tresi Weeks, and Deborah Irwin with Workforce Solutions. So we're glad you're here today. This is our webinar series of Lunch and Learn it's going to be running from 12 to 1. We'll definitely be done by 1 o'clock if you're planning. We are talking today about why do you need a special needs financial planner and why do you need a special needs attorney? Maybe what are some of the differences? So Tresi and I have two different roles. Tresi is an attorney and focuses her practice on special needs, and I am a financial advisor with my primary focus on special needs families as well. And so oftentimes Tresi and I were, talking about how every week we get calls or we get questions about, well, can you handle X for me? I get calls asking if I can set up a special needs trust for somebody, or if I could set up guardianship, and she gets calls about the finance side. So we're going to talk a little bit more about that today. So from a housekeeping perspective, your cameras are muted and your microphones, so we can't see you or hear you, but we know you're there and we're glad you're here. We do want to take as many questions as you have as we go through this. We are going to talk about several things in the special needs planning, realm, and things that maybe should be on your radar. And if you have questions about those things, feel free to put those in the chat. Deborah's going to be monitoring the chat. We're going to take the questions throughout the meeting, not just at the end. So having said that, Tresi, I am going to turn it over to you for your big disclaimer.
Well, thank you, Allison. Thank you for the opportunity to present with you. Just to let you know, of course, that by this presentation today, we're not creating an attorney-client relationship. Communications with my clients are protected by attorney-client privilege. This does not create that relationship until you actually hire us.
Perfect. Okay, so special needs financial advisors and special needs attorneys. Tresi, let's talk a little bit about attorneys and what your role is in the special needs planning process.
So what our process is we're creating the special needs trust. We might be creating wills for the parents, all of the legal documents that work as part of that plan. But we like to work with our clients' other professionals as a team because, as you know, having a comprehensive plan for the child makes it a lot better for that child, gives it a much better chance of working. So we do the legal part, and then the other professionals do the financial pieces.
Yeah, Tresi, I always refer to that you guys are the paper, and the paper is completely necessary. We've got to do that, and we're the money. So both sides of it very much matter. But because there's so many similar things that we're talking about, as far as having things in the right buckets. In fact, a special needs trust is necessary so they can have the right bucket, so they can have things. And that confusion and where those lines cross, I think that is where we see the common the common misnomer that we all do the same things. So a little bit of some of the things a special needs financial advisor does, they're going to perform needs analysis and protection plans and risk management. We do manage assets. We have a lot of the same licenses that a traditional financial advisor has, but we have some additional certifications. Members of the Academy of Special Needs Planners. We're also nationally certified as a Social Security advisor. So from our practice perspective, we have some background as it relates to special needs that some of the other advisors don't have, okay? We spend a lot of time talking about transition planning, special needs, and life. When it comes to transition and when we're a family that has a special needs child that might need care for the rest of their life, not just ours, it's like 3 retirements, right? If you're married, we have husband and wife, and it's, you might spend 25 to 35 years in retirement. But what if you have a child that has care needs 25 to 35 years beyond your own life? So we spend a lot of time, kind of talking about that and what the goals and what the future looks like. And what we say is we really try to plan for the worst. We hope for the best, because we work with a lot of clients that the jury's still out. We don't know. Our kids are not fully developed yet. They're not grown yet. They may have, developmental disabilities or maturity that may be, far beneath their actual age. And so we talk about planning for the worst and hoping for the best. And when we plan for the worst and the best actually happens, then it's okay, because your retirement is much better. It's awesome. So we're able to help you set up ABLE accounts. An ABLE account is another, I like to call them buckets or baskets of places where you can have money above and beyond the $2,000 that is allowed for SSI that won't be counted against you for that purpose. So we can help set up those ABLE accounts. ABLE accounts are for achieving a better life for an individual with a disability, and the disability had to start prior to age 26. And we have entire presentations about ABLE accounts and how to get those set up. We provide advocacy through resource sharing and referrals. And there's a lot of different programs that are available throughout the state, like Workforce Solutions, Texas Workforce Commission, vocational rehab, for instance. So we spend a lot of time connecting you to resources that might be relevant to you in your transition. And we're going to discuss and strategize on SSI, Medicaid, SSDI, and Medicare, as well as waivers. And we are also able to do a Social Security maximization analysis. And this matters because if you have a child whose disability started prior to age 22, then they have the ability to be considered for childhood disability benefits under a parent's record. And so the maximization of your own Social Security or your spouse's Social Security matters in these calculations. So a few of the other things, I think we kind of talked about some of the things. A special needs financial advisor, we provide financial advice. It could be fee-based or it could be commission-based. We're able to calculate future care cost estimates. So if you're a parent that says, I know that I have to plan for my child, like I definitively have a child that's going to need care for the rest of their life, but how do I plan for that? How do I come up with how much money do I need to save, or how do I fund this trust? We're able to develop those estimates, and we're able to develop various scenarios. So some families will come to us and they'll say, I know for sure that we want full residential care. Or another family might come and say, I know for sure that we want our loved one to live with us until we can't anymore, and so let's say 75. And then we have some people that want a caregiver in the home, or they want like day programs, transition programs. And so we're able to really do estimates on all of that. And we really do a good job at making sure that you have the assets in the right buckets to protect eligibility. Tresi, talk to us about assets in the right buckets and the nightmares that you have seen in your practice as far as things being in the wrong buckets and disqualifying from benefits. Talk to us about that.
Well, and just before I do that, I love that you're talking about all of these different issues, because I had a case many years ago where it was a single mom that had a child with disabilities that was not going to be self-supporting. So we did a will for the mom. We did a special needs trust for this adult child that was going to be funded upon the mom's death. But unfortunately, the mom became disabled herself due to an injury, and she ended up using all of her money on her own care. And so by the time she passed away, there was nothing left to that special needs trust. So it's great to work with a financial advisor that thinks about all of those different pieces. But to answer your question, when assets go to the child outright without a special needs trust, then that child can lose their eligibility for SSI or Medicaid. And so we've seen cases where the parent's money has to be used completely up before that child can re-access those benefits. And that really defeats the purpose, because we want the child to access whatever government benefits are appropriate, and then the parents' money would supplement that. So in many cases, we're doing a third-party special needs trust that's not funded until the parents pass away. And that's fine. Like you said, with the word bucket, it can be an empty bucket that is not filled until the parents pass away. And so we would have a will leaving that child share to the trust. We would have beneficiaries designated for life insurance, IRAs, and 401ks, so that everything goes to that trust upon the parents' death.
Well, you brought something up, and I try to bring this up every single webinar we ever have, about the importance, those beneficiary designations. So if you're taking notes, write this down. A big issue that we see in both of our practices is, the inappropriate beneficiary designations. And so first things first, you never, ever want to name your special needs child outright as a beneficiary on any accounts, any life insurance, anything you have, because that's pretty much going to disqualify them from SSI and Medicaid, right off the bat without legal action, right? But I would like to just take that one step further to say we're not fans of people putting their children, minor children, as beneficiaries either, unless there's some kind of future trust set up to where it's going to spell out how and when they're going to get the money, because 18-year-olds getting large sums of money, even though your kids are brilliant, just like mine, it's never a good idea, ever. So there's a lot of, talk about the workaround for that, because we see this all the time. Husband and wife, they make each other beneficiaries, and then they set up their children as equal parts as contingent beneficiaries, and they don't know any different. And that is the difference between a special needs advisor and a financial advisor. Your regular financial advisor doesn't think about that. They say yes, and they write this down, and it is a mistake. So talk to us about that, Tresi.
Right. So even for children without disabilities, if you name them as a beneficiary or contingent beneficiary and they receive that money outright, if they're minors, it's going to go into the registry of the court. And then the minute your child turns 18, they get all of that money outright. And I have not yet met an 18-year-old who would handle a large lump sum like that wisely. So what we typically do is in the parent's will or their trust is we create a contingent trust for these other kids, so that share goes to the life insurance would go to that child's trust. And then you would have a trustee named who would use it for your child's health, education, maintenance, and support. And then when your child reaches a certain age that you designate, they can either become the trustee of their own trust, or they can get whatever's left outright. And you choose that date. It can be age 21, 25, 30, whatever. And then for the child with special needs, we want to name that special needs trust as a beneficiary. And I'm glad you brought it up, Allison, because it is so important. When I work with a family and do their planning, I actually have them get the beneficiary change forms, and I write in the kids' trust information, and then they turn that in, because I want to make sure that the trusts are named properly for life insurance and IRAs and 401ks, whatever they've got. And that way, when the parents pass away, the money goes into those trusts, and then they're used for their child's care, and we don't have the negative results. But also, when you name a child's trust as a beneficiary, you can protect that inheritance, that life insurance. You can protect it from creditors. You can protect it from divorce. Lots of different protections that you can provide.
That's really good, and I'm glad you do that. We do the same on those beneficiary change forms, and we're sticklers. We even have emails that go out of reminder, have you updated your beneficiaries? So if you're taking notes, the note should be check my beneficiaries on all of my accounts, 401ks, 403bs, old pensions, any investment accounts you have, bank accounts, life insurance, anything where you can have a beneficiary, check your beneficiary, check your contingent beneficiaries. All of those companies and carriers have change of beneficiary forms that they will provide you. They'll email them, they'll fax them. You can fill them out yourself and correct them or update them, or once you have your documents done, you can correct them that way. Deborah, we've been talking way too much, and I see that we've got some questions. Run some questions by us.
Okay, we have a question from Ms. Sylvia, just wondering if you have this information in Spanish.
I do not. We get that
Unfortunately, I don't
question a
either.
lot. We get that question a lot, and what will happen is this meeting will go on our YouTube channel. So we do have a YouTube channel, and so this meeting will go on out there, and I believe that there is like a Spanish button that you can hit on the YouTube channel for that. And I apologize, we do not have anybody in our firm. We need to correct that. So sorry.
Okay, thank you. And then Suresh asks, do wills that fund the SNT after both parents pass away go through probate? If yes, is that a long process if the disabled adult child is the only child of this parent?
So Suresh, yes, if you have a will that leaves your assets to the special needs trust, and let's say that you've got a house, bank accounts, things like that, the will would have to be probated upon your death before those assets get in the trust. Now, assets with a beneficiary designated, like the life insurance and IRAs, those can go into the trust without the probate process. But assets that go through your will, like bank accounts, houses, and things like that, that will have to go through probate. Now, if you're interested in avoiding probate, you could create for yourself a revocable living trust and put your assets in that trust. And then whatever's in that trust upon the date of your death does not go through probate. So if you're interested in avoiding probate, there are some ways that you can avoid it. The question is it a long process? And it really depends on the county where you reside at the time of your death. Every county is different. Some counties it may take 2 or 3 months. Some counties it could take 9 months or longer. Just depends on the county.
Okay, and then Craig says, I have a will that says a trust will be created for my son upon my passing. If my life insurance beneficiary is a trust, does the trust need to be created before I pass?
So Craig, what you're referring to is called a testamentary trust because it's a trust within your last will and testament, and that trust is not created until you pass away. In a lot of our cases, we do a standalone special needs trust that exists now, and then we name that as a beneficiary. But it is okay to name that testamentary trust as a beneficiary if you don't have a standalone trust.
Okay.
And there was also a question, do you provide services in the Austin area? So both Allison and I, we represent clients all over the state. You want to make sure you go to a special needs trust attorney or advisor in your state because the laws are very different. We have clients from all over Texas, and I'm sure Allison does too. We don't handle guardianship in all of those counties, but special needs trust clients we have all over the state.
And we serve all across the United States, and we are based in Texas. We are in Fort Bend County, Sugar Land, Texas, but we serve all across the United States. And we have a lot of clients in Texas, so all over, for sure.
And then Kimberly wants to know, do you guys handle guardianship?
We handle guardianship right now. I'm only accepting them in Collin County. Typically, I also handle Dallas and Denton, but we're short-staffed right now, so we're not handling those counties. But you want to make sure that you have an attorney that handles guardianship in your county because every county is different.
Tresi, you said something a minute ago that I wanted to comment on, and is making sure that you're using basically an appropriate attorney and appropriate advisor, and I think that is really, really important. So first things first, most of this stuff is not a DIY project, right? Do it yourself. Now, can you do it yourself? A power of attorney and a healthcare power of attorney, sure. But the guardianship by yourself and the special needs trust, I would say I wouldn't. Okay, so there's reasons why professionals do this, and this is all we do, because there are a lot of hoops and loops to jump through and a lot of just common mistakes. Like we have seen mistakes on a pretty regular basis for attorneys that aren't specialized in special needs, are like just simply not having a Medicaid payback in a first party special needs trust or something whatever, right? So I would say that your situation is specialized. It is important that you work with specialists. So there are a lot of attorneys out there. There are a lot of financial advisors out there, and they're smart. I'm not, stepping on anybody or anything like that. They are smart, but they're smart at what they're smart about. So if, they can say, I can do a special needs trust, it doesn't mean that's what they do on a regular basis. We've seen some documents where people have paid lots and lots of money, and they were just quite frankly wrong. So what do you think about that, Tresi?
Yeah, so special needs law is extremely complex. And so it takes years and years to learn it, because we're trying to create a trust that doesn't disqualify your child from SSI and Medicaid. And unfortunately, SSI and Medicaid, they don't always come out with very clear rules about how they're going to treat certain provisions of trust. Some of it is written and some of it's not. So I spend a lot of time keeping up with what the local Social Security office will accept or not accept. How do they treat IRAs? Do they treat those as resources or income? All of those things, it's extremely complex. And so you want to make sure you go to an attorney who's very experienced in special needs trust, because yes, any attorney could probably find a form for a special needs trust, but that doesn't mean they're doing it right. It's not a forms practice. There's so much more involved. Even in our special needs trust, we're not just trying to qualify our client for government benefits. We also want to create a plan that works overall. And so I've seen many trusts created by attorneys that are estate planning attorneys, but not special needs trust attorneys that are fatally defective. And so if this is done incorrectly, it can cause severe damage to your child's future. And so to me, it's worth it to do it right. I've seen some people doing online wills, and my firm handles probate. And so when somebody passes away, their family comes to us with a will. They've done it online or with Susie Ormond or any of those kind of people. Every single online will I've seen was fatally defective. It did not do what the client thought it was going to do every single time. Probate costs a lot more than what it would have cost to do the plan right. So
I would like to say too, not to rain on anything horribly, but the legal plan, the group legal plans that you can get, where you might have that as a group benefit through your employer, they're usually not adept in special needs trust. A simple will, a healthcare power of attorney, a power of attorney, they can totally handle, but they usually do not have people that are adept in special needs. So I say just be cautious of that. So Tresi, if people have documents, they already have a special needs trust, maybe it was done a long time ago, or maybe they had it done by a family friend or who is an attorney, but maybe not special needs. Do you review other attorneys' documents? Is that something that your practice does?
We do. And so if somebody wants us to review their current plan, they can send us their current trust, schedule a consultation. We do charge $500 to review that trust, consult with you, but we also send you a worksheet so we can get to know more about you and your family, your financial situation, in order to determine if this trust is appropriate for you. So absolutely. We recommend that our clients come see me at least every 3 years. And then we touch base and see if there are any changes that you need to make. You might not ever need a change, but you want to make sure it's updated at least every 3 years. Sometimes the laws change, special needs laws change, family change, you might have change in trustees. So it's always good to keep those current.
For sure. Deborah, do we have some more questions?
Okay, we have a few questions. Yes. Okay, Kimberly asked, what is the best way to find a special needs attorney in my county?
Well, you don't need a special needs trust attorney in your county. You need if you're filing for guardianship, that's county specific, but special needs trusts can be done by any attorney in the state. There is an organization called the National Academy of Elder Law Attorneys. The website is NAELA, NAELA.org. And that is a group of attorneys it's not only elder law attorneys, but people like me who are special needs attorneys are also members of that. So that's a good way to make sure that the attorney that you're working with knows what they're doing, because we all are, we keep educated on government benefits and how that affects the documents that we're drafting. Now, for guardianship, you want to make sure you hire an attorney who is certified to handle guardianship cases in the state of Texas. And so if you go to the state bar, you can just Google Texas Bar, State Bar of Texas guardianship certification. There's a list of attorneys who are certified to handle guardianship in your county. And then that would be a great resource to find a guardianship attorney in your county. And then, you know, there are some attorneys in the surrounding counties that will handle your county as well.
And the other thing I would say is that we have relationships all across the state of Texas with attorneys for special needs. So depending on your county, just reach out because we can certainly point you in the right direction of someone. And even if that someone isn't the someone, they will be able to refer you to somebody really solid that is. So like, for instance, like Tresi, for instance, they're doing guardianship in Collin County and not any other counties. But if you're in that area, you're Denton or Dallas or any of these other counties that are surrounding there, Tresi can also certainly provide some suggestions of people in that surrounding area that might be able to help with guardianship as well. Additional questions?
Yes, Jay asks, can an adult individual with co-guardians living in separate states and the individual splits time and education across states obtain state government funding for services from both states?
You know, I don't really know. My understanding is that the individual can receive benefits only from one state. And so they would need to designate which is going to be their home state. Allison, do you have a different experience?
I would agree that it's going to be one, not both. Like, they're not going to be covered by both Medicaid programs in the state. So seeing how the waiting lists for the waivers in the state of Texas are 15 to 18 years, the other state might be better. I'm not saying they are. They might be. So I would definitely lean in towards the state that may have better resources for special needs if you're pretty far out on that waiting list. I have never heard of someone being able to straddle two states to be able. I'm not saying it's impossible, but I've never seen it happen, and I highly doubt it. With as far as Medicaid, because I know for sure, like, if you move, so if you have Texas Medicaid, for instance, and you move to North Carolina, then you got to apply for Medicaid in North Carolina. So you don't just transfer your Texas Medicaid. You don't just keep your Texas Medicaid. So but you know what my question is, Tresi, here with the guardianship, if they're co-guardians and living in two separate states, does the guardianship, because usually guardianship is state related, county related, how does that work? And that might be getting in the weeds and we can move on, but how does that work in a co-guardianship multi-state?
Right, guardianship is typically, it's supposed to be in the county where the ward resides. So if the child moves to another county or state, they would need to have that guardianship transferred over.
Got it. Okay.
All right.
Deborah?
And Veronica is asking, can a special needs financial planner help me with my finances as well, or do I need my own financial planner?
No, that's exactly what we do. So we have some people that we work with that they say, hey, I already have a financial planner. I just want to work with you from a special needs perspective. Most of the people that we work with holistically on the whole big picture, because ultimately the deal is it's your assets and income that is going to be funding your retirement for 25 to 35 years. It is also your assets and income, the money in your budgets, that is going to be able to provide funding for the special needs trust. It's proceeds from your life insurance that's going to fund a special needs trust in the future. So if we have somebody that is adamant that, they want to just, have us help them on the special needs side, then we're happy to do that. But we definitely work with people completely holistically on the whole big picture, because ultimately it is you and your assets.
And then we have a couple of questions about the approximate cost to set up a special needs trust and check on government benefits, as well as like what is the range attorney service fee for will and S&T ballpark range. They're wondering about costs for the services.
Yeah, so Deborah, that's a good question. And so typically when I'm working with let's say it's a married couple, I'm doing wills for the parents. I'm doing the special needs trust. I'm assisting with beneficiary changes. And then as part of that package, we're also doing for the parents their durable power of attorney, medical power of attorney, HIPAA release, directive to physicians, declaration of guardian. A lot of other documents are part of that package. So for a married couple, if we're doing a basic package, it's $5,500. If you wanted to do, more complicated things, the fee would be dependent upon the complexity, but that's typically what you're looking at for the will package and special needs trust for that child.
And I would just say that that's in line. I mean, most of our clients, they need a special needs trust. They end up with one. And so that's what we see pretty generally across the board, as far as cost associated. Now, can it be more than that? Absolutely. But generally that's, kind of the range that what we're seeing. But let's talk about guardianship too, because that's something that always comes up too in general. And I know it can be contested and it can be ugly, but let's just say it's not contested. A person wants to, needs to get guardianship. Give an approximate range for guardianship as well, so that people can plan financially for that.
So that varies greatly. I was just talking to a friend this weekend and an attorney who handles guardianship in Harris County. The going rate there is $5,000. In, Dallas or Collin or Denton, you're looking at maybe $2,000 to $3,000. So it varies greatly by county as well. So there are some, if you're looking for a low cost attorney, there are a few attorneys that do, I call them mills, where they do kind of in bulk guardianship. So there are some that if you are on a very tight budget, there are some attorneys that do it for less. But if you're really wanting the full service, you're looking at $2,000 to $5,000 plus the court costs. Sometimes you're paying the attorney ad litem fee that represents your child. So it just depends on the county.
Yeah, and I would say, like for Harris County, Fort Bend County, what I've seen is probably $3,500 to $5,500 for guardianship. It kind of just depends. It's not usually $2,000. It's usually a little bit more than that. But I would say, on average, $3,500 is probably pretty close. Deborah, do we have some additional questions?
Yes. Jay was following up with his comment about the co-guardians living in separate states, stating that he was thinking more along the side of workforce services. So I could probably answer that. VR, Vocational Rehab Texas Workforce Funding, and our workforce services are state-based. So it will depend on what state you live in. If you want to get a little further on that, reach out to me. I put my email in the chat, but it is state funded. And then it looks like Martha is asking, what about getting the most of federal and state benefits? Is that part of the financial planning, SSI, SSDI, etc.?
Yes, and again, we're nationally certified as Social Security advisors. So yes, we do go deep and wide on that. And again, having money in the right buckets, when to apply, how to apply, what to do, consulting the Social Security Blue Book. What if your child is working? Is a substantial gainful amount? There's a whole lot to know about SSI and Medicaid and RSDI and kind of what triggers what. And honestly, we have whole webinars on that topic because there is just an utter huge amount of confusion on SSI and Medicaid versus SSDI and Medicare and which one's which, because one is a means-based program, which is based off of assets. And if your child's a minor, it's based off of your assets, not theirs. And one is a worker-based program. You pay into it as you're working. So oftentimes we we throw around the term Social Security, we throw around the term SSI, and we're confusing the two, and one you shouldn't qualify for, and when you will later. So so we definitely go. We basically we can charge hourly to apply for you, but I like to give you the tools and resources that you need to handle it yourself. And if it gets hairy and you need an appeal or there's problems, then we can step in and you know, we can be your representative for your case through the Social Security Administration. But we typically give people really good tools so they can go through the process. It's designed for a parent to be able to apply. It's not pretty. It's not nice. It's a government entity. But you can do it, and you don't know what you don't know. So we really like to empower families and empower people and give them the tools that they need to take charge of that and take charge of their applications and make it go away. So.
And Allison asks, if we establish a special needs trust while living in Texas, but move out of the country, does this trust become invalid?
So the special needs trust, and I'll answer a question you didn't ask, but if you move to another state, the special needs trust is valid, but I recommend that you have a special needs trust attorney in that state review it to see if there are any changes. If you move to another country, it depends on the country. Actually, estate planning across countries is governed by treaties between the countries, and it can be very complex. So you can have a trust in Texas, and if there's assets in it, there's money in it, and your child lives somewhere else, yes, the trust could be used for the child in another country. It just gets very complicated. Sometimes there are taxes involved in the other country. But special needs trust, if you move to another county, you don't need to make any changes. It's just if you move out of the state of Texas, you want to have it reviewed.
Deborah, I saw the question from the parent asking, you know, basically saying that, you know, maybe the disability is so low academic scores, been in special ed since 3 years old, but no specific diagnosis other than speech and accommodations in school. So if they're in special ed, I would assume there may be no other specific diagnosis, but maybe an intellectual disability, which is defined as an IQ of 70 or below. So would that qualify for government benefits? So and not getting in the financial conversation. So technically, if a person has intellectual disabilities, then yes, they would qualify for government benefits. But depending on assets and depending the age of the child, and those are kind of one-off conversations because there's a lot of what ifs. So if the IQ is not 70 or below, then it's going to have to be determined by the Social Security Administration, and they're going to use the Blue Book. So if you're taking notes, it's the Social Security Blue Book. You can look this up online. It's basically an impairment guide. So you're going to look up every single thing that your child may have deficiencies in or may have shortcomings. Every specialty that you take your child to, so if they go to cardiology, they go to neurology, they go to pulmonology, whoever they may go to, right? Psychology, you know, psychiatry, you're going to look that impairment up in the guide, and it's going to tell you exactly what you have to prove to the Social Security Administration to be approved or deemed disabled. It's going to, so it's actually spelling out the criteria of what they're checking the box on. And you either check the box or you don't. I mean, it's either you either fit in that guide or you don't. So it's not necessarily a yes or a no, and it's also not necessarily a yes or a no on autism. You know, we have kids that have autism that are super high functioning. They drive. They have high IQ. And they're, you know, so they're not necessarily disabled. So it's not a slam dunk, but there are a lot of presumptive conditions that are just automatically approved for SSI. Down syndrome is one of them. You know, muscular dystrophy, cerebral palsy, some of the other ones. But those testing on the poor working memory, processing speed delays, all of those other issues, the fact that you have an IEP, the fact that they've been in special ed, all of those things will be taken into consideration.
And if I may add something to that, a lot of people ask me, if my child is not yet on government benefits, should I do a special needs trust? And so what I tell clients is that if there's a chance that your child will not be self-supporting, let's go ahead and do the special needs trust. And that way, they have the option of being eligible for government benefits if they need it. If they don't need government benefits, it operates as a regular trust. But if they ever need government benefits down the road, then it'll operate as a special needs trust, and they can have the benefits plus whatever you've left in the trust.
Tresi, I agree with that 1,000%. But the other takeaway on that, because you were talking about a testamentary special needs trust earlier, and the other takeaway on that is already creating that trust. If you have parents or grandparents that might be leaving large sums of money or inheritance to your special needs child, that trust needs to be created. It's not a testamentary trust. That trust needs to be created so grandma and grandpa or mom and dad can leave money to that trust. Have you seen that as well, Tresi?
I'm so glad you brought that up. When I do the estate plan for the parents in the special needs trust, I give my clients a letter that they can give to grandparents or other relatives, that they can give to their attorney and update their will or their trust so they can leave assets to this child's special needs trust. And that's part of, you mentioned holistic. This is part of the holistic plan. We've seen many times where kids inherit directly outright from a grandparent because it wasn't planned. But grandparents can change their will or trust and leave assets to it. In some cases, grandparents may want to put money in the trust while the grandparents are living. And so it's great to coordinate that with the family members.
I love that you do the letter. We have seen that a lot. That's important. And so what we like to say is we want you to have meaningful, intentional conversations with your family members. It's not to get in the weeds with them about all their finances and how much money they have and how much you're going to get, right? That's not the reason, but it's simply having intentional conversations, kind of goes like this. Hey, mom and dad, we've been thinking and planning for special needs and for little Johnny, and we've learned some stuff along the way. We've learned about having money in the right buckets and how to properly leave things to the special needs trust for Johnny in the future. And we've done some things. We've got we have a healthcare power of attorney. We have power of attorneys. We've set some things up. We wanted to share some information with you, but, and I just realized that, that we should probably share this with you as it relates to your own planning. So you're not poking, you're not like prodding into their business, because I know that some parents and grandparents, want to keep their cards pretty close to their chest, and that's okay. But your parents and grandparents that plan to leave money to your special needs child, they want to do it right. And guess what? Your mom and pop advisors have no background whatsoever in special needs. Like it's like 1% of the population of financial advisors have background in special needs. So they're not getting this information. And so they could accidentally leave money in the wrong bucket to your child in that regard. So talk to us a little bit more about some of the things that you guys do, Tresi.
Okay, I'm answering a question here. Somebody asked,
Sure.
Are Tresi and Debbie a part of CPG? No. So I am with the Weeks Law Firm in Plano. We're not connected with CPG at all. I know Allison and respect her, and she's just helping to coordinate this thing. So we're not part of the same thing. Somebody asked for our website, and so.
And that's going to be at the end for sure. And I always say, we don't work for them and they don't work for us. We partner with agencies and firms and programs all across the state. And we don't, we never necessarily endorse or don't endorse or whatever, but we just, and I probably should have shared this at the beginning. I'm a mom. I'm a mom. I have 4 kids. I have 2 with special needs. I've got one that's transitioning. I have one that already transitioned. And so I'm pretty passionate about connecting people with resources. I found the process as a parent unnecessarily difficult. And I do this for a living, so I can only imagine how other people feel as they're going through this. It's hard. And so that's why we partner with these organizations all across the state, because we want you to learn about other organizations, who they are, who they serve, what they do, how they can help you in your journey. So that way, your long list of things that you need to get taken care of as it relates to special needs planning, as it relates to documents, you can start taking those things off your list and feeling better about it for sure.
And Allison, did you ask me a question? I forgot.
Yes. So I think we've hit on some of these things already. So I'm just going to keep on moving. So, ultimately, again, they don't work for us. We don't work for them. They don't do what we do. We don't do what they do. But together, when we're working with you, we come together for your overall greater plan and greater understanding. When your documents are done, we update all of those beneficiaries. Although, Tresi, if you're going to do all our forms for us, we'll let you. No, I'm just kidding. But we work once your documents are updated to where we can update all of your beneficiaries and all of your accounts and things like that. And anytime that there's an additional updates or anything like that, then we keep your documents on file. In our secure files, we'll keep your documents. Something happens, follow up. We have procedures in place for our aging population to where we can have a designated person that we can talk to on their account as they're aging. If they become no longer of sound mind or body and those types of things, we can do that as well. So from an important planning perspective, we've kind of talked about protection plan, lifetime care, transition planning, ABLE accounts, and advocacy. It sounds like a lot. It sounds overwhelming, but we like to put that in bite-sized pieces for you and develop a roadmap for you. Kind of here's where you are, here's where you want to go. We do a lot of listening because when we say we're holistic, we're really custom designing plans for people based off of their needs and their individual goals and kind of where they want to go. And everybody's situation with their child is a little bit different. So definitely holistic and definitely tailored specifically to your family. So a couple of things. I think we're coming around the bend from a time perspective. I think we might end a little bit early. These are a few things that should always be on your planning radar. We've kind of hit the tip of the iceberg on some of these things. We do have a YouTube channel. We have recorded presentations. We always record our presentations, and after each one, we put them out there on our YouTube channel. So if you miss one, or if any of these topics on the list might be important to you, you can go back and visit that on YouTube. One of the things, we've kind of talked about a lot of things, but one of the things that we didn't talk greatly about is child support. And so in the state of Texas, we often see that child support continues post-18 for a special needs individual. And if that is your case, write this down. If that is your case, you have some real things that need to happen before you apply for SSI and Medicaid. So Tresi, talk to them about that, about special needs, a first-party special needs trust and child support being redirected.
Yeah, I'm so glad you brought that up. And so child support is considered income to your child for SSI and Medicaid purposes once they reach the age of 18, regardless of whose name is on the check. So what we do is we create a first-party special needs trust, and then I work with the family law attorneys. They have to get the court to order that support be paid into a first-party special needs trust. That way we don't cause the child to lose eligibility. A lot of family law attorneys are not familiar with the way to do this. So it's very crucial. And so what it means, so for example, let's say that a parent is ordered to pay child support of $800. And let's say we've got a child on SSI getting $794 a month, and then they're getting Medicaid, and they need Medicaid for this child to survive. If that parent is ordered to pay $800 in child support, that's more than SSI. That means the child loses SSI and Medicaid. So instead, we'd have to go to court and have that support order to go into a first-party trust. And that way the child can get the $800 in child support plus the $794 of SSI plus Medicaid. So it's very tricky, but very important to be able to get both so that you're not disqualified. And again, a lot of family law attorneys aren't aware of that. So I do the special needs trust portion of it, and then the family law attorneys do their part. I provide them language they put in the decree, the child support decree that the judge signs.
And so a couple of things on that. If you are going through a divorce, I'm sorry, but you should bridge these conversations on the front end. It's easier on the front end than to go on the back end. Another thing is if you have two willing parties, the mom and dad, it doesn't have to be expensive. But one thing she said that is important that you understand, it does need to be signed off on a judge. So if you don't have to fight about it, getting the child support redirected, I mean, it's the same amount of money, but I've seen people fight over it. But if you don't have to fight over it, you can have a attorney draw it up. You guys both sign off on it. The judge is going to sign off on it. It doesn't have to be crazy expensive to get this done. But one of the things that I will say that is important, and you said it, is the judge has to sign off on it. Because we had one family one time that said, well, I already have a special needs trust. So I just went into the AG child support system and just changed the bank account to the special needs trust account. And so that is like, it doesn't work that way. You might have been able to do it, but it is wrong. And if it catches up with you, then you could end up in an owing situation of owing back SSI and all of those things. So it gets really complicated. So if just know that you do need a court order and that you do need to work with an attorney on getting that done.
Right.
And again, prior to age 18.
Let me add one more thing, Allison, is that some people have a third-party trust. You cannot have child support going into a third-party trust. It has to be a first-party trust. So like in the case you gave, it might have been a third-party trust, and that would have disqualified the child.
And that is another example of working with an attorney that is not focused on special needs. They might not know on the first party versus the third party and things like that. So it starts getting complicated. Again, complete webinars out there about these topics. But that is just one thing that we have seen. And the thing is the Social Security Administration, it might be 5 years before they catch up with you and they'd be like, oh, you've been getting child support. Well, they weren't eligible. And now you owe us $100,000. I mean, people get letters like that. It's really real. So start those conversations early if you've got somebody turning 18 sooner versus later. So that way you can get moving with that, because it will affect your application. This is our team at Consolidated Planning Group. I work on a collaborative team of professionals, and oftentimes I'm out doing the webinars. And so I always just like to take note that we definitely have a team behind us, and we're definitely ready to work with you. We are a member of the Academy of Special Needs Planners. We're also nationally certified as Social Security advisors and members of MDRT. I would just like to say, thank you, Tresi. Thank you, Deborah. Thank you for being with us today and partnering with us. We've got Tresi's contact information on the screen. We have recorded today's presentation, so later today or tomorrow you'll get an email with a PDF of our slides, as well as a link for the recording and the contact information for both of us and how to reach us. So having said that, Deborah, do we have any additional questions?
No, we do not.
All right. Well, thank you, ladies. Thank you, everyone, for being here. And I got 12:55. We're in this 5 minutes early. So I hope everybody has a great afternoon. Take care.
Thank you, Allison. Bye-bye.
Thank you.
Bye now.